Well, well, well. It looks like Fani Willis is finally having to pay up for all the trouble that she put Ashley Merchant and the Merchant Law Firm through when it came to a Freedom of Information Act request. Now, we've been talking about this at length. We know Fani Willis multiple times has refused to give out information she's legally required to give out. We saw the same thing with Judicial Watch, and we even got to see Ashley Merchant in court going up against the DA's office, Dexter Bond, and trying to push them to say, you guys, you should have to give this information out. We want to know what happened. And Fani said, no, we're not going to do it. So now Fani is being ordered to pay over $54,000 to the Merchant Law Firm, which is absolutely insane. We've got some breaking news here. We're going to get into it. Also, shout out to 11 Alive for reporting on this. Here we go.
Well, we are following some breaking news tonight at 6 as a judge has now ordered Fulton County District Attorney Fani Willis to pay more than $54,000 for violating the Open Records Act. Zach Merchant with our 11 Alive political team broke the story. And Zach, you just got a copy of that court order. What have you learned here?
We did. We just got a hold of this Fulton County Superior Court order just in the last roughly 15 to 20 minutes.
Here we go.
In it, Judge Rachel Krause rules that DA Fani Willis violated the State Open Records Act by failing to turn over documents requested by defense attorney Ashley Merchant. The judge wrote that the defendants, the Fulton County DA's office, were openly hostile to Merchant and failed to handle her requests in good faith. Merchant had sought a copy of confidentiality agreements signed by DA's office employees, as well as a list of attorneys hired by DA Willis. Judge Krause today gave the district attorney 30 days to pay Merchant $54,000 in attorney's fees and to turn over those requested files. Spokespeople for the DA's office did not immediately return requests for comment.
Yeah, of course they're not going to say anything. And then we have Ashley Merchant here celebrating a major win. She says, proud that we have judges willing to hold people in power accountable when they ignore the law. Shout out to Ashley Merchant and the Merchant Law Firm. We're actually going to get into the document here, and I'll show you guys why Judge Krause made this decision. Judge Krause is actually someone familiar to the community here on the channel because she is the one who actually said, Glanville, you got to go. Sorry. You've been messing up in this trial. I'm not going to say that you messed up, but you're going to have to get up out of there. So Judge Rachel Krause in here again, willing to put in the work here in Fulton County to make things right. So let's go ahead and look at this judgment by Rachel Krause and see what she actually said. Final judgment and order. This matter came before the court for a final evidentiary hearing regarding the plaintiff's Second Amendment complaint for injunctive relief and attorney's fees and litigation expenses pursuant to Georgia's Open Records Act. It's pretty straightforward. Having considered the evidence at the hearing, heard the arguments from the counsel, reviewed the relevant law, and being aware of the record as a whole, the court hereby enters the final judgment as follows. Here we go. Applicability of Open Records Act. Of course, they should have given the information. This court previously found the defendant subject to the Open Records Act. That finding is supported by the Georgia Supreme Court's subsequent decision in Gonzalez versus Miller. A district attorney's office is not only a subunit of the state government. It is distinct legal entity recognized, and let's keep going through here, by law and specifically described by the legislature as an office. Whatever the outer bounds of the term office as used in the ORA may be, a district attorney's office fits within those bounds. And Miss Willis, as the elected district attorney, is the ultimate custodian of her office's public records. Basically, you can't pass the buck, Fani. This responsibility falls on you. The defendants have never asserted that the records sought were not public records or were exempted in some manner from ORA. Therefore, the only remaining issue for the evidentiary hearing was to determine whether the defendants had substantially complied with the obligations of the ORA. Compliance with the Open Records Act. Under the ORA, an agency or custodian of public records has 3 business days upon receipt of an open records request to determine whether and how to produce or permit copying and inspection of the open records. Do y'all think Fani did that in 3 days? I don't think she's done anything in 3 days other than, well, I'm not going to say that. Within those 3 days, the custodian must either provide, produce, or access to the records, purpose a timeline for doing so, or specify in writing the specific legal authority exempting such records from disclosure by code, section, subsection, and paragraph. So you got to explain and say why you don't want to give this information. If the custodian fails to affirmatively respond to the open records request within 3 business days by notifying the requesting party of the determination as to whether access will be granted, the ORA has been violated. And then Judge Krause cites a case here. In any action brought to enforce the provisions of this chapter in which the court determines that either party acted without substantial justification, either in not complying with this chapter or instituting the litigation, the court shall, unless it finds that special circumstances exist, assess in favor of the complaining party reasonable attorney's fees and other litigation costs reasonably incurred. You got to pay up if you violate this. Whether the position of the complaining party was subsequently justified shall be determined on the basis of the record as a whole, which is made in the proceeding for which fees and other expenses are sought. Although substantial justification is not defined in the ORA, the term is used and defined elsewhere in the code. And she goes through to explain it there, right? In response to some of the plaintiff's open records requests, defendants acknowledged their receipt of the request, but there is no dispute defendants did not advise the plaintiff affirmatively within 3 business days. Are we surprised? Fani thinks she can do whatever she wants. Fulton County voted her back in, so maybe she's right. Whether any records would be made available. Thus, the defendants failed to comply with OCGA 501870 and violated the ORA. Further, based on the evidence offered at the hearing and the record as a whole, defendant's failure to comply was not substantially justified, and the plaintiff is entitled to attorney's fees and litigation expenses, as we just saw there. So what is that going to amount to? As noted during the hearing, the defendants, through the open records custodian Dexter Bond, that guy was a mess, were openly hostile to the counsel for plaintiff Miss Merchant and testified that Miss Merchant requests were handled differently than other requests. You cannot do that. For example, Dexter Bond indicated that he refused to communicate by telephone with Miss Merchant, despite testifying that his usual practice is to call a requester to get additional information when a request is unclear. But basically, Dexter Bond said, nah, we ain't doing that. Sorry, Fani. I'm not going to do it. I don't feel like helping Ashley. And Fani's like, all right, I'm not worried about it. While there's no requirement under the ORA for Mr. Bond to call any requester about a particular request, Mr. Bond's handling of Miss Merchant's request in this manner indicates a lack of good faith. Yeah, he didn't like her. And he made that very clear when he was on the stand. The evidence at the hearing also demonstrated that Mr. Bond failed to produce or meaningfully inquire about numerous non-disclosure agreements based on his unnecessarily limited interpretation of the request as pertaining only to media agreements. After Mr. Bond consulted with defendants counsel, Mr. Bond understood the request to include confidentiality agreements and produced 22 such agreements. Later, an office-wide email was sent and numerous other agreements were identified and produced. They said, oh, we found it. Oh, look at that. Mr. Bond also testified he did not conduct any searches or make other meaningful search efforts in response to the plaintiff's request for promotional and rebranding materials, claiming he did not know what the request sought and there were no searches to perform. Wow. And considering Dexter Bond's testimony and the records as a whole, defendant acted without substantial justification under 501873 in failing to comply with the Open Records Act. Defendant's failures were intentional, not done in good faith, and were substantially groundless and vexatious. Wow, I have not heard that word. Shout out to Judge Krause for learning this over here. All right, so here's the relief, and here's what the I don't want to say the Ashley Merchant Law Firm, but the Merchant Law Firm is going to get. Because defendant lacks substantial justification for failing to comply with the ORA and no special circumstances exist, the plaintiff is entitled to attorney's fees and litigation expenses, as well as injunctive relief compelling the defendant to provide certain public records. Attorney's fees, what do they get? At the hearing, the plaintiff ordered without objection testimony of affidavits of Ms. Merchant, Mr. Merchant, and their paralegal, Sierra Burdorf. In addition to the itemized records of the work performed and the affidavits as to each employment background and experience, in this case, the plaintiff charged an hourly rate of $300 for work performed by each attorney and $60 for work performed by Sierra. The plaintiff claims the total fees of $54,264. Wow. Based on Miss Merchant's 78.7 hours of work on this case, Miss Merchant's 89.1 hours of work on this case, Mr. Merchant's 89.1 hours of work on this case, and Sierra's 65.4 hours of paralegal work, amounts supported by their respective timesheets. The plaintiffs also provided without objection its expense summary and associated receipts for filing fees, service fees, mailing postage fees, and other expenses incurred in connection with this case, totaling $1,339.23. The fees and litigation expenses sought by the plaintiff, except as otherwise noted, are reasonable, necessary, and justified based on the attorneys and paralegals' professional experience. All right, so the total amount is coming to $54,122.23. Now, even though Fani has to pay this, Judge Krause says she's not done because they still have to produce some documents. Oh my gosh. Having found that the records request by the plaintiff are public records not subject to any exemption, defendants are required to produce the following requested documents. So they got to pay up and they have to produce the documents. To the extent that they have not already produced a copy of the NDA confidentiality agreement that the employees were required to sign, the list of attorneys hired by Fani Willis. Ooh-wee. The request sought a list of all attorneys with their names and dates of hiring hired by the district attorney since Ms. Willis became the district attorney, including the date hired. So we got all that they've got to put in there as well. And then in conclusion, Judge Krause says, based on the foregoing, the court hereby enters final judgment in favor of the plaintiff and against defendant as ordered as follows. No later than 30 days from the entry of this order, the defendant shall file a notice of compliance with the court certifying under oath that the defendants have complied with this order by A, performing appropriate searches of all employee emails and the DA's office files and records to ensure that all potential locations for responsive documents are searched. They have to provide to the plaintiff all responsive material without redaction, alteration, deletion, or modification in any form to protect sensitive information in accordance with Uniform Superior Court Rule 3617 and explaining in detail efforts undertaken to locate responsive documents and detailing search conducted, including identifying emails to individuals and or the DA's office wide emails as reasonably necessary regarding the existence of responsive materials. And no wonder Judicial Watch wants a special master in this. Because we shouldn't have to go through all this. Judge Krause shouldn't have to give this judgment saying, hey guys, make sure you do your job. Hey guys, make sure you go through and you show and you explain in detail how you went through and actually found these documents, what the process was, where you looked, where you didn't look. It should be so simple, but we know with this DA's office, it's not that way. No later than 30 days from the entry of this order, defendant shall deliver to the plaintiff payment in the total of $54,103.23. The plaintiff shall be entitled to collect post-judgment interest. If the defendant fails to comply with any of the terms of this judgment, the court may award the plaintiff attorney's fees and expenses incurred in obtaining defendant's compliance. So if they have to go back to court they're going to have to pay even more. This court retains jurisdiction to enforce compliance with the terms of this judgment, so ordered this the 14th day of March 2025. Y'all give it up to the Honorable Judge Rachel Krause. Did a great job with this one. Shout out to Ashley Merchant and the Merchant Law Firm. They got a great win. And Fani costing us more money here in Fulton County. I'm getting sick of it, to be honest. And Fulton County, shame on us. Shame on us for allowing this to happen and continuing to happen. We'll see if it makes it another 4 years. Y'all have to let me know what you think about this in the comments and in the chat.